Good day. Welcome to Legal Easy. Today we will discuss marriage and ante-nuptial contracts. While you can say married, before you say I do, it is important to consider the marriage regime that you and your spouse-to-be have in mind. There are three possible marriage regimes in South Africa: marriage in community of property, marriage out of community of property, and marriage out of community of property, but with the inclusion of the accrual system. The basic difference between the three are the following. Marriage in community of property. If the husband and wife did not enter into an ante-nuptial contract before the wedding, which provides for a marriage regime in terms of which there will be separate estates after marriage, then marriage will automatically be one in terms of community of property. This marriage regime is exactly what the name suggests, namely, husband and wife share a common estate after marriage, and all property appropriated by either party after marriage becomes part of the joint estate between the parties. There are a few exceptions, of which the most important is property acquired by way of a bequest. Such a bequest, upon becoming the property of the party, forms a separate estate of that spouse to the exclusion of the other. Generally speaking, each spouse will have the power to deal with the assets of the joint estate, and in so doing will bind the joint estate, save in the case of damnation of an asset which will unreasonably prejudice the interests of the other spouse. Upon divorce or the death of one of the parties, the joint estate is divided. The share of each party who is married in community of property can best be described as an undivided 50% share in the assets of the joint estate, including immovable property. Section 7 of the Divorce Act provides that in the determination of the benefits to which the parties may be entitled, the pension interest of a party is deemed to be his or her assets. The spouse who seeks to share in the other spouse's pension interest is required specifically to apply for such an order. A spouse may obtain relief against the other spouse in the event of dissipation of the assets of the joint estate by the other spouse. A spouse may also seek an order against the other spouse forfeiting the benefits of the marriage in community of property in certain circumstances. Marriage out of community of property. Parties who wish their marriage to be one out of community of property are required to sign an ante-nuptial agreement wherein provision is made for such a regime. Such ante-nuptial contract should be signed before an attorney who has been admitted as a notary before the date of marriage, failing which the parties will be considered to have been married in community of property. A marriage out of community of property is one in which the parties do not have a joint estate, and property acquired by either party before or during the marriage remains his or her property during and after the marriage. For instance, at divorce, parties may nevertheless decide to purchase property jointly, for instance, immovable property, and if such property has thereafter been registered in the names of the spouses jointly, the spouses will, in respect of such immovable property, each have an undivided 50% share in the property. Lastly, marriage out of community of property, but with inclusion of the accrual system. In this marriage regime, property acquired by each party after marriage will, during the existence of the marriage, remain the property of such party exclusively. Yet, upon the demise of the other party or divorce, certain principles will apply by operation of Chapter 1 of the Matrimonial Property Act. In terms of such principles, the party whose assets have shown less accrual acquires a right against the other spouse for payment of 50% of the difference between the accrual of their respective estates. It is important to keep in mind that before the date of marriage, parties to the ante-nuptial contract are required to agree in writing upon the existence and commencement of the parties' assets. Parties also need to specifically state all assets that are agreed to be excluded from the accrual. Parties who intend to participate in business activities individually will normally be advised to make one of the latter two marriage regimes applicable to their marriage, as there will in such a case be a need to have freedom to deal with assets and money without any obstructions that would be placed upon either of them by the requirements of a marriage in community of property. Spousal maintenance. In certain marriages, one spouse may have a claim against the other for payment of maintenance subsequent to divorce. Yes, this is not a matter that is required to be dealt with in the ante-nuptial contract. In conclusion, it is important to think, speak, agree and consult an attorney before you say I do.